Mistrial. Here we go. Some news headlines. Let's go. Hey, gun people. Well, I wanted to get out here and give a little update on a couple of rumors that are going around. And I don't know if the rumors are true, and none of us really know for sure. So people that repeat things as if they're facts, kind of like the law, it normally isn't true. Hopefully I'm giving you some insight from a cop and detective and working at the DA's office for all those years to where you understand a little bit better. But for us to know exactly what's going on is kind of tough. So they're saying mistrial with prejudice, defense team files motion, withheld evidence. So if you remember during the trial, they said they filed this through email and they put it in writing. And I said that was a good thing. For some reason, people are just picking this up and they're thinking it's been filed after the jury got the case. This was filed, according to the date, before the jury got the case. So the judge already had this information. It's not like it's coming out that all of a sudden, oh my God, they just filed because they just found out. And now they're going to get a mistrial. Look, if the judge was going to give this, he would have already gave it. He wouldn't let the jury waste their time. He wouldn't be tying this up. So the judge, obviously, and again, I've said there's always a motion for mistrial in just about every case I can remember. And usually the lawyers throw out a bunch of things, and that way it sets up for an appeal. Then when they appeal, if one of the appellates find one of their reasons good enough, they may get an appeal. So it's kind of like, almost like a setup for an appeal. And I'm not saying this is the case here, but what everybody keeps saying is they hid evidence on, and this is according to trendingpolitics.com. They put up the document, which I appreciate. Too many news sources don't put up their source now, but they posted these documents. So, and again, I think I've seen this on a couple sites, so I'm not sure if they copied this or if this is the best copy they have. So some places it's hard to read. But so for the motion of mistrial, they go into the different things. But the thing that people keep sending me is, oh my God, they hid a tape that cleared him. I'm not so sure that's the case. So if you want to pause this, I'm pausing here. So in case you want to pause it yourself and read all this, you can. So here's we get into the resolution of the video. On 5 November, remember today is the 15th. The jury has had it for 2 days. This is the second day of deliberations. So on the 5th, of day of mistrial, the prosecution turned over defense footage of drone video which captured some of the incident on August 25th. The problem is the prosecution gave defense compressed version of the video. What that means, and you want to describe this in case the judge doesn't know, and I'm not sure if this is the correct version of compression. I think there's always some sort of compression when you do videos, but I don't really understand what they're talking about compressed version unless they shrunk it down and they weren't allowed to unshrink it. Because I can send you a compressed file and then you can uncompress it and it'll be a regular file. So I'm not sure if that's what the prosecution did, and it's sleazy. It makes the defense work harder. Let's shrink it down, and if they don't know how to blow it up or uncompress it, then that's their problem. But we gave it to them. And I'm thinking that's what the defense is probably going to say, but we'll see. What that means is the video provided to the defense was not clear as a video kept by the state. Now, if that's true, then we do have a case of the defense is hiding evidence from the defense. If it's exculpatory, if the court finds it is exculpatory, which means it should have been discovered, or it should have been given over to the defense, then the DA can be held. Let's see, the full size of the defense video, that's what was discovered by the DA, is 3.6 megabyte, but the state's is 11.2. Again, if they shrunk it down and compressed it, and then you uncompress it and it brings it back to 11.2, then there's no misdeed. It's a pain in the ass. It's not making their job easier, but I don't think they can say that the DA hid information from them by giving them a shrunk down or compressed version. But if they compressed it to where it can't be decompressed, and that compression made the video less, viewable, which it would, obviously, it's less than half the size, so you're going to lose pixels, and you're going to lose clarity, and you're going to lose all kind of stuff. Normally, the bigger the size of the video, the more clear, the better it is. if you have two videos and they're the same video and one's bigger, you got more clarity in the bigger one. So, if you have a regular video and you make it into HD, it's going to be a bigger file normally. I would think. Maybe I'm wrong, but that just common sense wise. So the dimension of our video was 480 times 212, and the state's dimensions was 1920 by 844. Well, obviously, if you're viewing something this much larger than this, you're going to have better clarity. The question is, could the defense uncompress this and then they would have the same size? And again, the judge may or may not explore that. He may go, whatever, I don't find that that's enough. Deal with appeal. There's some judges that are like, I don't really care. Deal with it in appeal. I'm doing my ruling, appeal. I don't care if I get overturned. And this judge has been around for a while, so I really don't think he really cares, although most people just don't want to do that. It just doesn't sound good. So the resolution of that video, however, was not. The state, that's the DA, did not provide the quality video to the defense until Saturday, November 13th. Okay, so I thought it was November 15th when they discovered it. On November 5th. Oh, okay. So this happened on the 5th. Now on the 13th, they only did so at request of Wiseau 2 days after losing the argument. Now, this indicates deception, planning, conspiracy. They did it on purpose. They did it intentionally. But I'm telling you, I've seen DAs do this all the time. They screw over the defense and they go, I'm sorry, Your Honor, it was an oversight. The person, they always have someone else. The person that discovered this did it. Our video person misunderstood our instructions and he was told. And they won't have a big hearing. The judge won't go, bring in the person you told. I want him to testify that he misunderstood. They never do that. They just let the weaselly, sleazy lawyers from the government say their thing and they give them the benefit of the doubt. That's why it's so hard to get these crooked DAs out and they just do so much damage. Let's see. So until specific attorney Wiseau requested it, ordinarily when mistrial is granted on a motion of the defense, it is presumed that the defendant has made the election to abandon the valuable right of being tried before a single tribunal. I'm not sure what the hell that thing means. A single tribunal. Does that mean a bench trial, a judge versus a jury trial? I'm not sure. However, a different rule applies when a mistrial motion is introduced by prosecutorial overreach. Anytime you get prosecutorial overreach, hiding, misconduct, that's an issue. But again, saying it, knowing it, and proving it is different. I mean, these guys may be absolutely true, but can they prove it? And lawyers know you can't prove it unless I admit it. And lawyers know not to admit it. I go back to Jeff Rising. When he was being deposed or testifying, he said, I don't remember, I have no recollection, like 30, 50 times. And lawyers know that. If I don't admit that I lied, all I have to do is I have no recollection. That's not how I remember it. I don't remember that. I don't remember ever doing that. I have no recollection. I mean, any reasonable person knows they're lying, but you still can't prove it. Let's see. In such cases, constitutional prohibits against double jeopardy will be retrial. Okay, state the following elements: prosecution action, intentional, sense of culpable state of mind, awareness of this activity is prejudicial. Again, you could say all this, prove it. Unless Binger gets up there and goes, yes, Your Honor, I confess, my state of mind was to prejudice the defense and because I wanted to win, and I did it on purpose. Unless he says that, it means nothing, people. All right. Mistrial, in order to get another kick at the cat, I call second bite of the apple, whatever. Because the first trial is going badly. So, do I think this mistrial is going to be granted? I doubt it. Could it? It could. Somebody blacked this out and had their emails. Another page I looked at, it wasn't blacked out. Yeah, on this website, it's not blacked out. I don't know if they're trying to dox them. I mean, this is an official court document, so this information is out there. And it's only a business address anyway, so I'm not sure why they blocked that out. But anyway, so what do I think about this big mistrial? Look, he filed his motion. He got it on the record. Can the judge suddenly decide, yes, I'm going to grant it? He can. But the odds of him doing that and letting the jury deliberate is less and less, because if the jury reaches a verdict, now it comes into overturning the verdict. So if he was going to do it, I think he would have done it before, and I think the defense is setting up appealable motions that they filed, so now they can appeal. Now let me address another rumor. Well, I found this when I was roaming around things saying somebody was quoting me on here. I'm like, I hope they quoted me right. I don't mind being quoted, but sometimes people misquote you. And I kind of read it real quick, so I don't really. What side am I on here? I don't even know. Okay, I'm on Target Freedom USA is the one I'm on. And I think I used this site the other day to get all this information, but I didn't know they had used my name or was quoting me. But that's not the rumor I wanted to carry. The rumor I wanted to carry or talk about is this jury thing. Let me get to my other jury thing. So I'm getting 1,000 comments that Guns and Gadgets put something out. Now, I'm not picking on Guns and Gadgets. Don't go over there and say, Rick said you're full of shit. You don't know what you're talking about. Look, the guy's putting out information. I don't know if he knows it isn't real. I don't know if he knows the thing. To me, supposedly he put out, I didn't watch the video, that a marshal secretly called him, told him he's got a source. And this is what people are telling me. Again, I did not watch his video, so don't go there and tell him I'm cracking on him. I don't know what he did. I know how people misrepresent when they put comments. My comments led me to believe that he has some secret source at the courtroom that told him there's 2 jurors that are holding up this case because they're fear of the outcome. And I call BS. Whether it's BS on him, whether it's BS on his source, whether it's BS on who's spreading this rumor, I call BS. And here's why I call BS, people. Not because I'm smart or super talented and all this shit. I'm just telling you, jury deliberation rooms, they're designed to be to where nobody can hear. You really have to make sure that nobody can listen and intimidate. All the jurors take an oath. You heard the judge read to them saying, you will not be swayed by what I think, what the attorneys think, by what the media thinks. They go in there knowing that they need to make a decision. And if they can't do that, they need to notify the judge. I don't think I can give a fair verdict because I'm scared. And they will be removed, and that's why we have alternates. So for someone to tell me that someone's got a secret source and this U.S. Marshal is going to run around and somehow spy on a jury, which is illegal, then he's going to pass that information along to Guns and Gadgets, or someone else quoted, after I heard Guns and Gadgets, then somebody else said that, who's that group that does the, a lot of the, shit. Project Veritas. Someone else said Project Veritas as a source. So I don't know if Guns and Gadgets got it from them, if he got it, or they got it from Guns and Gadgets. I mean, when you start rumors like this, it just flies. Look, I'm telling you, if a judge heard that somebody, first of all, I don't know why there would be a U.S. Marshal there anyway, unless it's a state. Some states and counties have marshals. And so maybe this isn't a U.S. Marshal. Maybe this is a county marshal, because some counties have marshal. But normally, the bailiff is the one that guards the jury room, that protects them, that keeps people. I mean, look, I heard the DAs all the time walk up to the bailiffs. Hey, man, any news from the jury over here and thing? And the bailiffs would always go, no, man, I can't say nothing, or I didn't hear nothing, or you know I can't say that. But the DAs, the crooked DAs that work for the government, trying to pull with their crooked little bailiffs because they're in the government, so there's this bond, the blue line, whatever you want to call it, and they would try to get the bailiffs to give them information on what they're hearing in the jury room. The only time people know what's going on in the jury room is when they send a note to the judge, and then the judge calls in both attorneys, and both attorneys and the judge knows, and then maybe they call out the juries to, explore it further. But for anyone to believe, and you can believe what you want, I don't believe it, that somehow some marshal secretly heard or spied on the jury, and not only did he not hear just like one word or 2 words, he actually heard a full-on conversation to come to the conclusion that there's 2, specific number, only 2, that are scared, and that's what's holding up the verdict. I don't believe it. It's too many if, and, buts, and coconuts. I call bullshit, and I think if the judge thought this was true, he would haul that jury out and say, there is a rumor that there's two of you holding out because you're scared. And if you're scared to give a verdict, I want to know right now, is that true? And he would ask all the jurors together. And if the jurors didn't admit to it, one of the other jurors say, yes, Your Honor, there is two jurors in here. I don't want to identify them because they don't want to identify, but there are two. And they would deal with this. So for people to run around and keep spreading, I mean, I just can't believe the number of comments I got on Rick, two jurors are holding out. And people are saying it like fact now, like it's absolutely true. I'm sorry, people. I don't buy it. You can believe what you want. I'm not calling you dumb for believing. I'm not saying you're not smart. I'm just telling you from my experience and the way jury deliberations are protected, it's highly, highly unlikely. And I would say it's slim to none and slim left town, but there's always a chance. All right, we'll end that there. I'll let y'all know, or I'll try to go live if we get more info on a verdict coming out.